Very happy to see everybody here today. You've seen there's coffee, condiments in the back of the room. Please help yourself. We thank you all so much for being here today. We are here with Cornell Smith Mierl Brutocao, and this is the first of a hopefully kind of series that we'll do on some important legal topics. And as you know from being in HR or in the legal employment field, the changes have been coming at an increased rate. And hard to keep up with everything that's going on. So we picked a couple of topics here this morning that we thought would be helpful. We've been getting lots and lots of questions on these issues. Some of our partners have spoken on this. My name is Steve Mierl. I'm so happy to see so many people here today. Ted Smith, Betsy Chesney, Connie Cornell, and Scott Brutocao are going to present the various topics. So we're going to start off with the new issues on the Fair Labor Standards Act. And I'm so happy to have Ted and our partners here. Not only are they great attorneys, but they're some of the nicest people I know. So they are going to instill you with great wisdom on these new and very important topics. So Ted, please.
Thanks, Steve. Appreciate it. Man, that was quite an intro. Wasn't expecting that. Can everybody hear me okay? I'm a walker, so I don't like to stand behind the podium, but I am tethered to this, which is our video here. But hopefully I can speak loud enough for everybody here in the back. We've got three sets of speakers. There's three topics we're going to cover. The first one are the new changes to the Department of Labor rules on wage and hour, and that's what I'm going to talk about. And what I'd like to do, we've got a small enough crowd that if anybody has questions, please feel free. Just let me know, and we can answer them as we go along. We'll have a Q&A at the end as well if there's any follow-up questions that you have. But rather than me just droning on and on, it's so much more interesting if somebody other than me is talking. So hopefully we can get some of that going. I think it's important to think about the Department of Labor rules, the Fair Labor Standards Act, a little bit historically, just so we can understand where the government is going on this. Wage and hour issues, overtime issues, hands down, the biggest area of employment law that we've seen over the last 10 years, and I'm sure you've seen it in your organizations as well. Overtime lawsuits, the Department of Labor, they've been the biggest type of employment claim that we see. And it's been a major priority of the Department of Labor, as you can see up here, that their two stated goals over the last 8 years has been to take care of two areas. One, the overtime issues, and two, independent contractor issues. I'm really only going to focus on the overtime issue, but you should be aware that the independent contractor matter is something that the Department of Labor is definitely looking at as well. And the idea behind it is the Department of Labor's view, and it's kind of hard to talk about this without getting into politics. I'm going to try to avoid that, but it's almost unavoidable. We will all certainly, or at least 50% or maybe, this is Austin, maybe 40% of us are going to disagree as to which political philosophy you may ascribe to. But what the Department of Labor's view is, which is really the most important view in the room, is that the people who are working should be employees, number one, instead of working for themselves, and two, they should get paid hourly and be entitled to overtime for hours over 40. That's the default rule. So sometimes our clients seem to forget that there are exceptions to the rule, which we'll talk about. We call them exemptions. It would be easier if they called them exceptions, because that's what it is. But the bottom line rule, the default rule, is that everyone is an employee unless you're working for yourself, and everybody should be paid hourly plus overtime. Now, the historical background of that is the Fair Labor Standards Act came into play back in the Depression area. And so what happened in that point is that the government was trying to get companies to hire more people. So the idea was if you have 60 hours worth of work, it would be better to have two people do that, either hire two part-time people at 30 hours a week, or have somebody who's full-time and then an added part-time person for 20 hours. They wanted to get more people in the workforce. So the way they did that, to give incentive to the companies, is to make it more expensive to have the same person doing the job after 40 hours. That's the time and a half side of it. So if you keep that in mind, I think that helps to understand a little bit where the law was going at the time and why we are where we are. So I just want to give you an idea about how important the Department of Labor is looking at this. In fiscal year 2016, the budget request for the DOL Wage and Hour Division, which is the division of the Department of Labor that handles overtime and independent contractor issues, they asked for $277 million and 300 new full-time equivalent employees. If you compare that to 2015, it's an increase of $50 million. If you compare that to the previous administration, it's far beyond that. It's just a completely different set of imperatives, if you will, priorities with this administration. In fact, under the previous administration, there were cuts to the Wage and Hour Division. So there are more investigators. They're putting a big emphasis on making sure employers are abiding by these laws. By the same token, in addition to the government, there's been an explosion of private lawsuits that have come out on these overtime matters. If you look at here, there's been 8,961 new FLSA lawsuits filed in 2015. 1,000 of those here in Texas alone. It's an all-time high for FLSA lawsuits. And if you compare it to back in 1993, which to me doesn't seem all that long ago, it's gone up by almost 8-fold. And there's a reason for that, not the least of which is that plaintiffs' attorneys, employee attorneys, it can be a very lucrative area for them. You get not only the back wages, you get a liquidated amount, a double amount, and then most importantly, they get their attorney's fees. So it can be a very lucrative area for plaintiffs' attorneys. On top of that, it's an easy way to get class actions, or what we call in the FLSA, collective actions, because if you're likely paying one of your assistant managers incorrectly, and we always pick on Radio Shack because they were one of the first ones to get nailed on this. But if you're Radio Shack and you pay your assistant manager incorrectly, you have 3,000 plus assistant managers across the country. That's an easy, you only have to prove it once. And then you have 3,000 folks that are involved. So that's why these lawsuits have come to the forefront. What's important for everyone in the room is, unlike many of the employment law statutes out there, it doesn't matter how many employees you have. You don't have to have 15 or 20 or 50 or more. If you have 2 or more employees, essentially, you're going to be covered under this act. So it literally covers every single company in America. So what are the new rules that we're talking about? What the new rules have done in a nutshell, and we're going to go through it step by step, is I think the easiest way to think of it is they have set a new minimum wage for all salaried employees. So they've moved the salary test up, and we'll talk about where that is now. But that's what they've changed. There hasn't been any changes to the duties yet, but just to the salary. So what does that mean? Real briefly, as most of you probably know, there's 2 tests that you have to meet in order for somebody to be exempt from getting an hourly wage plus overtime. Otherwise stated, that's the exception, right? You have to meet a duties test, or do you have the kind of job that allows you to be exempt? We're going to talk about some of the 3 biggest ones just really briefly, the executive, the administrative, and the professional. So you have to have the kind of job that allows you to be exempt. And then, of course, you also have to meet, on top of the duties test, you have to meet the minimum guaranteed salary. Both of those tests have to be met. It's the salary test that has been changed by the new rules. So what are some of the exemptions? There are lots of different exemptions that are out there. In addition to these 3, there's a creative artistic exemption. There's that applies to like graphic designers, things like that. There's a Motor Carrier Act exemption that applies to truck drivers who are driving more than 10,000-pound vehicles in interstate commerce. There's a computer exemption. There's lots of different exemptions that are out there. The 3 I wanted to focus on are kind of the main ones that should probably come up the most in your organizations. So the executive exemption, this is management, basically supervisors, right? So if you're a supervisor, meaning that you supervise, you manage 2 or more full-time employees, and that means that you have the ability to hire them, you have the ability to fire them, you have the ability to discipline them, you have the ability to direct them, then you can meet the executive exemption. Now, you can still have somebody above that person who has to approve the decision, as long as that approval authority gives significant weight to what the manager is doing and recommending, whether that's recommending that the person be hired or terminated or disciplined. So that's the executive exemption as far as a duties test goes. The administrative exemption is probably the one that is the most confused one of all, because everybody thinks, well, that person's an administrative assistant, they do administrative type work, well, they must meet the administrative exemption. That's not really how it works. I think the easiest way to think about this is that they're in charge of a department really more than anything, right? And I think if we use the human resources manager, for instance, versus a human resource generalist, I think it's a good example. The human resources manager, or the vice president of HR, has a lot of discretion and judgment on what? The handbook, what kind of policies we're going to put in place, how we're going to handle different personnel issues. They may be giving advice on whether we should discipline this person or not discipline that person. They have a lot of independent discretion and judgment in the policy making of that entire department. If you compare that with an HR generalist, that person's job may be much more clerical, which would be, I help people fill out their documents, their I-9 form, their tax documents. I give them the handbook and I have them sign off on it. I may even give them some orientation, this kind of thing. That person doesn't really have any independent judgment or discretion as to what the policies are or how we're going to handle the paperwork. They're just basically going through the motions as they're told to do. The HR generalist would likely not meet the administrative exemption, whereas the vice president of HR would. So that's kind of the difference there. Are there any questions on that one? That's one that gets confused a lot. All right. Finally, the professional exemption. This one applies if you're performing work requiring advanced knowledge. Advanced knowledge basically can come from either an advanced degree in science. These are normally folks that have a licensed degree. So you have doctors, you have lawyers, you have CPAs versus non-CPA accountants. That's been a class action area that has gone over nationwide, where some of the biggest accounting firms in the country have found themselves in litigation, differentiating between their more junior attorneys versus their CPAs. And again, what it goes back to there is, what's your independent judgment discretion? Are you just, as a junior accountant, are you just kind of going through the motions, kind of a recipe, and everything has to be approved? Or are you more of the CPA who's actually making the bigger picture calls on whether this meets the tax, I would say tax loophole, but Bill would not have appreciated that. Ability to not have to pay tax on that particular aspect of your income. So a lot of that goes into play on that. That's the professional one, exemptions, that's the key. Whether you had an advanced degree, and oftentimes you have to be licensed. That's where the CPA, the JD, the MD, those kind of degrees come into play.
Do you find the role?
Sure, and so what that type of person could fall into either potentially the professional exemption or the computer exemption. The computer exemption, and I'm really taking sort of a 30,000-foot view on this. There's reams and reams of cases and stuff on it. But generally speaking, the computer exemption applies to programmers, software engineers, these kind of folks who are actually programming the computers, the servers, et cetera, versus going in and maybe being the help desk or assisting just with troubleshooting, these kind of things. So when we're dealing with the tech folks, I think that more often they fit into the computer exemption than they do the professional exemption, because even though you're getting a certificate, what was your advanced degree? Did you get a master's degree? Did you have to get a PhD? These kind of things. It gets more complicated on that. The exemption that we normally see in that situation is more of a computer one. But we see in other areas too, engineers. You have the PEs, professional engineers, versus the non. There's cases and cases on these, and it's a case by case basis. Honestly, that's what can make it confusing. Is you have to go in and see what their duties are. And any of you have gone through either a Department of Labor audit or a private lawsuit, how do they figure out what they're doing? They go in and they just ask them. Right? They have an investigator come in. They go to the conference room. They say, "Tell me what you do. Tell me about your day-to-day activities. What are you responsible for? What do you have judgment on? What can you change? Those kind of things." So it's really important that you have good job descriptions to start off with. because that job description isn't necessarily going to be the be-all, end-all, but it at least gives you a framework from what the company believes the duties are and should be for this position. And it's, everybody hates to do job descriptions are the last thing that HR folks, it's just that's your, task number 853 of the year, but it really is important to have for that reason. Any other questions? Great. So let's get to the new rules. So we've been talking about the duties test. That has not changed so far. There were some rumors that were out there that there may be some potential changes coming down the line on what kind of duties would be required for the white-collar exemptions. That has not come down so far. The only thing that's changed is the salary test. Currently, in order to be exempt, in addition to having the right type of job under the duties test, you have to get a guaranteed salary per week of $455 per week. That's an annual equivalent of $23,660. The new rule that has just come out has bumped that to $913 per week. So, pretty much, more than doubled that. It's now an annual salary of $47,476. So that, again, I think the easiest way to think about this is that is now the new minimum wage that has to be paid for all of your salaried exempt folks. You can argue about what duties they have, that kind of thing, but at the end of the day, if they're not making at least $913 per week, it's not going to matter. They are going to be deemed to be non-exempt, and they're supposed to get hourly plus overtime. Yes, ma'am. So there is some amount that can be based on bonuses if they're not discretionary type bonuses. They need to be pretty much what do I want to say, non-discretionary. You're going to get it. It's not one of these kind of things that the more it gets tied to the performance of the company, the profit margin, these kind of things, it looks like that's not a guaranteed amount that you're getting. So that's the key. It has to be a guaranteed level of compensation that they get, and that's where the problem gets in with bonuses. With the commission employees, you're going to be able to take that into account. The other thing that we're going to talk about later is they've also changed the amount of the highly compensated level. So it used to be $100,000 to meet the highly compensated, and it's now, I got to look at that, it's more than $100,000. It's like 130 some thousand. Right, and if you're an outside salesperson versus an inside salesperson, then you have that other exemption that's out there. So there's all kinds of different ways that could come into play. But generally speaking, it needs to be a guaranteed income at that level.
Doesn't it also have to be paid quarterly?
Yes, right. So why have they set it at this number? Some folks, have had lots of clients who are like, oh my gosh, this is just coming out of left field. It's out of the blue. Why are they setting it this? Going back to the historical background of the law, the idea was, again, the majority of people should be paid hourly plus overtime. So the idea was at least 60% of the working population should be hourly plus overtime, meaning they're looking at the top 40%. All right, well, we'll do this 40 percentile, and we may allow those folks to be salaried if they meet all the requirements. Well, because the laws had not been changed in such a long time, that 40th percentile had dropped way down. So what they've done now, and again, taking the politics out, you can take it for what it's worth, but what the talking points are is they're moving it back to the 40th percentile. So that's what they want to set it at, is to make sure, again, we're back to at least 60% of the people getting hourly plus overtime. So it's not quite out of the blue. There is some method to the madness. And the other big change is, for the first time, they're actually going to tie it to an automatic escalator. So up until now, each time that they were going to change the salary amount, they had to go and either change the rules or get a different vote from Congress. And that is going to be a big change, where now it's going to be tied every 3 years. They're going to look at this escalator based on inflation, again, to make sure that it's tied to this 40th percentile of the salaries. So that's going to be a big change. And of course, what that's going to do is it's going to keep having that salary go up. So employers are going to need to keep an eye on that. Know that every 3 years there's going to be a change, and you're going to need to keep up with it. So let's talk about the highly compensated employees. Again, the increase is from $100,000 to now an annual minimum of $134,004. What does this mean? Basically, if you're a highly compensated employee making above now $100,000 and soon to be $134,000, all you have to do is meet one of the requirements of being exempt, one of the duties tests. So it's not that where there may be 3 tests under any particular exemption. If you meet one of them and you're under this, you make over this amount, then you're going to be pretty much deemed to be exempt. It's sort of a bright line rule, if you will. So now, why again did they go with $134,000? Again, it's tied to the percentile. The idea when the law was passed is that we're really talking about some of the highest compensated folks in the workforce. They set it at 90 percentile. Again, because it hasn't changed over the last several years, that percentile has gone down. Now all of a sudden, we're not at the 90th percentile, we're much lower than that. So they're setting it to go back essentially to what the status quo was supposed to be. Because inflation has caught up so much, they're now moving it back to the 90th percentile. So again, can dispute whether that's a good thing or a bad thing, but that's the method to why they are setting it at that amount. Are there any questions on that? Yes.
What comprises the full-time salaried employees?
So again, it goes back to, it all keeps on the same deal, what the guaranteed amount is, right? So whether you have discretionary bonuses, non-discretionary bonuses, that kind of thing. But the thought is you want to have as much of a guaranteed amount of compensation as possible, and the more that it can fluctuate, the less that it's going to look like that's a guaranteed amount.
In terms of
Who are they looking at? That's a good question. Luckily, I know the answer to this. The 90th percentile is actually nationwide. The 40th percentile, they based it on the lowest. They looked at the region that had the lowest census on it, and it actually turned out to be the South. So when they did the census, they're looking at the different regions to see, okay, who's got the lowest median income, and we're going to set it at the 40th percentile there, and that was for the South region. But this one is based on a nationwide average. Good question. So as we talked about the duties test, there haven't been any changes to that so far. Remains to be seen what will happen as things go on. But right now, there have not been any proposed changes to the duties. So when is this all going into effect? The new rules are going into effect on December 1st, 2016, assuming that they don't change before that. Now, there are lots of efforts going on legislatively to try to derail it, to try to change it, this kind of thing. You have to read the political tea leaves. Everything that I've read is that it's very unlikely that it would be able to be changed between now and December 1st, 2016 when it goes into effect. It has to do with the number of votes that are there. Of course, President Obama has stated that he'll veto any change that comes along before December, and it doesn't appear that there's enough votes to override that. So for all intents and purposes, the betting folks are betting on the fact that this is going to go into effect on December 1st. Now, we have a national election coming up. All that could change. My personal thought is, based on historical background too, once a benefit like this comes into play, it's real difficult to pull that back. Not impossible, but real difficult. So the vast majority of our clients, and the reason that we're having this seminar today, they're planning on these changes going to effect on December 1st, 2016, and want to make sure that they're ready for it when that happens. So what are some of the options that employers have in my last 5 minutes here to talk in handling this? If you're going to have somebody who's going to remain exempt, meaning that you can have them work as many hours as you want during the week and not have to pay them overtime, you only are going to have one option, and that is to raise the minimum annual salary to $47,476. There's no amount of creativity or sleight of hand or legal maneuvering that can be done on that. If you want to keep an employee exempt, you're going to have to raise the minimum salary to that level. End of story. How about your non-exempt employees? Well, one thing that you can do, and I think we're going to see more of this, we haven't seen it as much, frankly, up until this point, but is having a salaried non-exempt person or utilizing some of the fluctuating work week. And why is that? I think some employers are looking at the thought of you've got a lot of employees who have been used to getting a salary, And there's somewhat of a hierarchy, if you will. Yeah, there's sort of some esteem that goes with that. They view, if you're getting a salary, that means you're part of management. So the thought being that, well, instead of moving these folks to hourly, we may move them to a salaried non-exempt. Now, what does that really mean in practicality? They get paid that salary for the week, but as soon as they hit 40 hours in 1 minute, you've got to convert that to an hourly wage, pay them their time and a half based on that. The other thing that is a possibility is to utilize the fluctuating work week. It's a similar type situation where you're getting a guaranteed amount even for that week. The benefit to employers is if you set it up correctly, if you give the correct notices, if there's an agreement in place, then what you can do is utilize just only paying them half time for the hours over 40 instead of time and a half. If you're going to go that route, you really want to make sure that you talk to your legal advisors about that to make sure that you've got that in place, because there are pitfalls there. But that's a real possibility. Of course, what you'll want to also do is manage the overtime. The only thing that changes really when you go from salaried to hourly only kicks in once the overtime kicks in. So if they don't work any hours over 40, there's not going to be any change to your company's pocketbook. The key, of course, is making sure that you're actively managing that, that people aren't answering emails from home, they're not traveling, they're not getting to work early, they're not working through lunch. All of these things that come into play with your current non-exempt employees, you're going to need to take into account as well. The thing that's going to be a little trickier is, especially if you're dealing, who's this going to affect the most? Assistant managers, these kind of things. These are folks who are used to not being on the clock, who are used to having more flexibility and more freedom, frankly, to do what they need to do. And there's going to be a bit of a challenge, I think, in overcoming that mentality going back to hourly. Now, one thing that is good is that if you feel like you maybe should have classified some of your employees differently than you classify them now, it's a great opportunity to do it and to blame it on the U.S. government. Perfect, right? Hey, the rules have changed. We've looked at things, we've analyzed things, and based on these new rules that are coming out, we are now going to move this category of folks to hourly. So if you were ever at a position where you felt like, oh, gosh, when we should really make a change and we're waiting for the right time to do it, this is probably the right time to do it. So, correct. Now, that's exactly right. Now, there's various different ways that you can do that. Any electronically based is the best, right? And there's all kinds of different ways now in the office setting that you can do that with computer programs and things like that.
Can you repeat the question? I don't think everybody.
Sure. So the question was really hypothetical. She has her neighbor's company is thinking that they may need to change some of their categorizations. So talking about going to the salaried non-exempt and some of the challenges in having these folks track their time, and also the issue of they have a vacation policy that they keep fairly open and don't make people track their time to do that, and whether they need to make the change to both to make sure that there's not some kind of discrepancy, discrimination, disparate treatment kind of going on. And that's all correct. All those things should happen. It's not a good idea to have some folks, keeping track of their time based on their vacation when other people should at the same time as well. Ideally, if you can have an electronic system, that's the best. It takes the human error out of it. It takes, the fudging part out of it. But that being said, there's no requirement that it be electronic. You can have people keep track of things, timesheets. You can do that. You just have to have records that are adequate to be able to show to the government or to private attorneys and the judge that we were keeping track of their hours, we were paying them for all the hours worked.
What about companies that they should be doing?
So there's not really a grace period here. That's why they're announcing it in advance. So, technically speaking, once December 1st hits, if your folks are not being paid correctly, they're not being paid correctly, and that time starts starts adding up, right? So each day, your 3-year time period that somebody could go on the statute of limitations starts rolling on December 1st if they're not being paid correctly. So you're going to want to make that change as soon as possible. There's not a grace period time to do it. So if you have people who are in this category, who are exempt right now and are being paid less than what this minimum salary is, you really should be looking at what you're going to do before December 1st, because it's going to be a rush and it's going to be here before you know it.
And if they get dinged and forever that.
Sure. So for these folks who would actually get caught up in just the minimum salary, it's going to start December 1st, right? So, but there's a 2-year normal statute of limitations period that you can go back. So you start the day they file the lawsuit or the Department of Labor comes in, and they can go back 2 years from that and see if you were improperly paid. 3 years if it's willful. Unfortunately, it's not that difficult to prove willfulness, so oftentimes that 3-year statute of limitations goes in. But as far as this particular new salary, that 3-year time period or 2-year time period would start December 1st. So if you don't make your change until January 1st of 2017, there would be a month there that you could have some liability. I am already going over my time limit, so I want to make sure and let everybody have other folks time to talk. And we will have a Q&A at the end. And, of course, we'll be around to answer any questions you may have. So I really appreciate your attention and great questions so far. Thank you.
Thank you.